Good afternoon. Thank you for coming over here. For the record, please state your name and the organization you represent.
Good afternoon, members of the Select Committee. My name is Goh Yihan, and I'm the Dean of the SMU School of Law.
The evidence you'll be giving today will be before the committee will be taken on oath. If you so desire, you can take an affirmation. Clerk of Parliament, please issue the oath.
Yes. I, Goh Yihan, swear that the evidence which I shall give before this committee shall be the truth, the whole truth, and nothing but the truth. So help me God.
Please be seated.
Thank you.
Welcome to the public hearing of the Select Committee on Deliberate Online Falsehoods. The focus for today's evidence gathering session is for us to ask you, put questions to you, and you have taken a solemn obligation to answer our questions truthfully. I will now call on Mr. Edwin Tong to ask his questions.
Good afternoon, Prof. Goh. Thank you again for coming here to assist this Select Committee. Now, we've been through your report, and I think your focus has been to look at how Singapore can prevent and combat online falsehoods. Would that be correct?
Yes, that's correct.
And the emphasis in your paper would have been to look at the current regime in terms of the legislative framework, what are the judicial remedies and executive actions that can be taken.
Yes.
And you have also applied the current regime to three very prominent examples elsewhere in the world where deliberate online falsehoods have affected those countries and the people in those countries. And you've also analyzed the current suite of options we have in Singapore against those events, correct?
Yes, that's correct.
And your conclusion, which I'll ask you to elaborate on in a minute, is that our current legislative framework is insufficient to deal with those scenarios.
Yes, that's correct.
One of the points you raise is that whilst the existing legislative framework is sufficient to deal with the offences in terms of the perpetrators, they don't deal with the falsehoods themselves.
Yes, not all of them.
Which are being purveyed.
Yes,
can you elaborate
correct.
on that?
Yes, of course. If I may just start off by bringing us through three characteristics of deliberate online falsehoods that I think any legislation would need to address, and that I think sets the background of my submissions. I would say that there are three important characteristics of deliberate online falsehoods. One, they are cross-border in nature. They are cross-border from a geographical sense, in that the falsehood might originate from a foreign country and finds expression in Singapore, amplified through local notes. They might also be cross-border, and I think this is important, in the virtual sense. They might originate in the virtual space, but yet they find expression in the very real physical realm we are in. That means that any legislation that deals with online falsehoods need to deter and punish such conduct. The second important characteristic is that deliberate online falsehoods are rapidly and easily spread. And so any legislation would again need to deal with this nature of online falsehoods. The third is that deliberate online falsehoods usually have serious, sometimes irreversible consequences. And so I think any legislation also needs to take this into account, not so much by only a takedown provision, but also by way of clarification and, if necessary, an apology. So with that background in mind, I just want to sketch out three purposes I think any legislation would need to have. One is to punish and deter. The second is it needs to prevent the spread of online falsehood. This can be by way of a removal process, or it could be by way of preventing or restricting access to the falsehood. And the third are remedial consequences. That is to say, any legislation needs to deal with the serious consequences by way, as I mentioned earlier, a clarification or an apology. So those, I think, set out really the background to my submissions in my paper. And if the committee so wishes, I could bring you through very quickly the existing legislation and explain why there are gaps in the legislation.
No, I think that's been sufficiently set out in your paper. So we thank you for that, but we've taken on board the views that you set out there. Would you comment, though, on one point? In your paper, one of the arguments you raise is that the existing legislation requires certain additional features or certain additional factors to be established before the three aspects of the online falsehoods that you've just mentioned can be addressed.
Yes.
Can you perhaps elaborate on that point?
I think this refers to the second purpose, right? That
yes,
falsehoods are rapidly and easily spread, and the question is whether existing legislation covers this point of online falsehoods, I bring to the committee's attention Section 15 of the Protection from Harassment Act, popularly abbreviated as POHA. So Section 15 allows aggrieved persons to apply to the district court for court order that the falsehood be removed or continue to be published with some clarification. Now, I think the point here is whether or not this process is sufficiently quick to deal with the rapid spread of online falsehoods. And I would submit that the judicial process, while it's important, whilst it needs to be thorough, may not be sufficiently fast to deal with the rapid spread of online falsehoods. Now, what I think might be quick and efficient is the executive action found in the Broadcasting Act. And as I stated in my written submissions, the Broadcasting Act covers 3 kinds of licenses. And if one were a licensee, then the Broadcasting Act allows the authority, the IMDA in this case, to take down the provision, to take down the material quite quickly. Now, in response to Mr. Tong, your question, I would suggest that an appropriate approach might be a 2-stage process. The first is a quick executive action that is aimed at removing the falsehood or preventing its spread. However, it is important also to balance that with an independent judicial oversight, and this means the statement maker can then apply to court to show and explain why the statement should be reinstated. Now, this way, I think it balances the interests of all parties. On the one hand, it responds to the quickness by which such falsehoods spread, and secondly, it also balances the statement maker's point about making his statement.
So in other words, to strike the right balance between
Yes.
this, trying to arrest the speed with which the virality of the online falsehood is spreading, and also that of the interest of the statement maker itself.
Absolutely. And if I may venture to suggest further, this is not something that's unfamiliar with civil lawyers, for example. When one applies for an interim injunction, the court grants the interim injunction not on the basis that there's an absolutely successful case, but it's convinced that there are irreversible impact that's caused by the action to be injunct. And that allows the other party to go to court to set aside the injunction.
Right. Thank you. Thank you, Prof. Goh.
Thank you.
Chairman.
Mr. Shanmugam, go ahead.
Thank you for your paper, which was very clear. Can I ask you philosophically? I mean, the approach, as a lawyer, you would appreciate this. We have a whole framework of laws to say what is wrong in the physical world. And conceptually, there can be no objection for having that framework applied to the virtual world as well. I mean, what is illegal in the physical world must also be illegal in the online space. Would you say that conceptually?
Yes, conceptually, I agree with that. And indeed, what matters is the impact on the physical space.
Thank you. I have no other questions, Chairman.
Ms. Chia, go ahead.
Prof. Goh, thank you for your submission and also the summary of the legislation highlighting the gaps for us. I just want to clarify, what you mentioned about dealing with the issue of the falsehoods that have been posted. So your suggestion actually was to allow executive action to take down the falsehoods and then followed by an avenue of appeal or recourse. Is that right?
Yes, that's correct.
Why do you think that is better than just executive action without any cause for redress?
I think it's important for us to balance all interests on the table. Just as much as the falsehood might cause serious consequences, it might also be that the statement maker has a reason to put it up or that it's not actually false. And so I think to address that interest, we need to have the statement maker, afford the statement maker a recourse.
Thank you. And would that approach only be addressed to the maker of the statement or to other perpetrators? Because as you are aware, you mentioned the virtual world, so it could also have gone round, it could have been circulated. So what is your suggestion over on this point?
I think the key here is who is perpetrating the statement, and that might be the original statement maker. It might also be the service provider which provides the platform for the message to be communicated.
But would you also say that anyone who assists in the perpetration by circulating, would you include such persons as part of the people to be addressed?
Yes, of course, because what they do also has a similar impact compared to the person who originally circulates the statement.
Thank you. Now, if I look also at the examples that you have given, in relation, for example, to Hurricane Irma, really, other than causing public alarm, so assuming, I'm not saying it's not a serious issue, causing public alarm is a serious issue. So assuming it happened in Singapore, and it could be, would you think that a situation like this could be sufficiently dealt with under the Sedition Act?
Under a situation like that, the Sedation Act could be used if the situation gives rise to seditious publications and so forth. But beyond that, the weakness of the Sedation Act is that it is very limited in its scope. So what I'm suggesting is legislation that goes beyond the existing legislation that specifically enacted to cover the situation of deliberate online falsehoods.
In the case of the election of the French president, if the POHA, under local
Yes.
circumstances, would be the only piece of legislation applicable, what do you think would have been the implications? The
implication would have been that the affected candidate at the time, the now president, might have applied under POHA to set aside the statement that's made about his offshore accounts. But beyond that, if the statement were larger than that and it affected a larger class of people, then POHA may not be as effective.
In that case, what could have happened was that the French president could potentially have lost the election. It's all speculative, of course.
Of course.
But he could potentially have lost the election. It would have taken him too long to go to court. Now, however, if we took that situation out and it were just an ordinary person, then the existing legislation would have been sufficient.
Well, it depends, I think, on the impact of the statement. If the impact of the statement were rapid and serious and happened almost immediately, then Section 15 of POHA may not have been sufficient to help that person. I think the key question here is just how fast do we want to react to the statement? And if we want to react very quickly, then Section 15 may not be the best approach to go about it.
How would you suggest that we review or address the content and the consequences of the online falsehood by way of therefore differentiating the type of responses that we should have in order to address those?
I think the response towards deliberate online falsehoods cannot be centered on just one solution. There is no one solution, no one perfect solution to the entire problem. What I'm suggesting is merely looking at it from a legislative perspective, that if one thinks that there needs to be legislation, I've looked at the existing legislation and I've submitted that they are not sufficient to deal with the problem. But by no means do I suggest that legislation is the sole approach. We must balance legislation with education, as well as reaching out to different communities, as we have heard earlier today.
Okay, thank you.
Thank you.
Mr. Xia, go ahead, please.
Prof. Goh, good afternoon. I just have a question, one question for you. You highlighted that if there were any legislative tools for it to be effective, it must have three features: punish and deter, preventive and remedial consequences.
Yes.
Wanted to get your opinion on, where would you steer this? How would you steer this amongst these three features? Are they all equally important? If there's something that we should pay more attention to, bias towards, more weightage? What's your view on this?
I think it's a holistic approach, and all three are equally important. Of course, the speed by which you enact the different three of them will be different. For example, you want to take down the falsehood first. You want to address the consequences that is being put out by the falsehood. You can, of course, go after the offender subsequently, but that takes time because you need to investigate, you need to prosecute him. So the speed by which each of the three are put into effect will be different, but I will say that you need an equal approach and balanced approach for all three of them. Thank you.
Thank you.
Yeah, please proceed.
Oh, sorry. Thank you, Prof. As a lawyer, what would your view be in how we should balance the freedom of speech as against the issues that we are trying to address here, online falsehoods?
The freedom of speech is, of course, important. It is enshrined in the Constitution, but it is by no means absolute. And indeed, I think the freedom of speech would be compromised if we allowed falsehoods to be perpetrated.
Thank you.
Thank you.
Okay, if there are no more questions, Prof. Goh, thank you very much for participating in this select committee process.
Thank you very much. It's been my privilege.
We'll send you a transcript of today's proceedings. If there are any mistakes, corrections, please correct them and send them back to us.
Sure.
Thank you
very
once again.
much.
Sergeant
Thank you.
Arms.
Thank you.
Okay. I think we have finished taking evidence from all the witnesses scheduled for today. Are there any other matters? Well, if none, I adjourn the proceedings till tomorrow, Thursday, 15th of March, 2018 at 10 a.m. Thank you, gentlemen.
Thank you.